would do so, but my computer, I don't know what happens.
Don't
Every
worry.
time I try to, it doesn't work.
Thank you for reminding me. Now it's recording. Okay, so now use of force. Um, well, before I start, something that I think it's really useful to understand, like like the general topics and the regimes that we're gonna see today, is that all of them are like a consequence of another. The use of force, general rule, is prohibited in international law. What happened if, and it's, well, it have some exceptions, we will see those exceptions. But what happened if an state made use of force? We will see the other regimes that have that arise as a consequence of that use of force. And previous to that, also, what is like the main regime that is in the whole context of the prevention of the use of force, and when states carry out like that use of force, and it's the human rights regime. I like a little bit of a spoiler, but yeah, have in mind that every regime is a consequence of another. That is really important. So, okay. The use of force, like a brief historical background of the use of force. As you may remember in class, Enrique always mentioned that in the League of Nations, one of the main reasons why the League of Nations fails is because it did not prohibit the use of force. If I don't remember wrong, the article that talked about use of force was like states should abstain or something like that. It was more like a recommendation, but not something mandatory. After the Versailles Treaty in 1928, we have the Kellenbrecht Pact that also aimed states to renounce to use war as a political tool, but again, did not make like a binding resolution about states should not use force between one and another. So, in that reasons, of course, there was no legal rule that prohibited the use of force. Second World War starts. We all know what happened next. And then it arrives the United Nations. So here we are. In the United Nations, that was one of the biggest change from comparison from a comparison of League of Nations to the United Nations, and it is that in Article 2.4 of the UN Charter, it does prohibit the use of force as a mandatory, like yeah, like a mandatory resolution that states must not make use of force from one another. In that Article 2 are like the whole principles of, well, not all principles, but the main principles of the United Nations, one of them being non-intervention, the non-use of force, and that is the general rule. Because what the United Nations system established is that the force, like the use of force as a political tool, is going to be entitled, well, the Security Council is the one who's going to be entitled to authorize and manage the use of force among states. And it is the UNSC, the United Nations Security Council. It has the monopoly of the use of force. It manages and it authorizes when a state can use force. And when a state does not comply with the general rule of the prohibition of the use of force, and even when it claim maybe self-defense, we're gonna see what is self-defense. But if an state claims self-defense and it was not self-defense, well, the Security Council has three main sanctions. There are the non-use of force, the well, the non-military sanctions, passive, the passive, yeah, the passive military sanctions, and the active military sanctions. If I don't remember wrong, those are in Article 41 and 42 of the UN Charter, like the last two. And some examples of the passive use of force is like, for example, um, when states block their airspace and yeah, they don't allow another state to pass through that airspace, or when they make some sort of demonstrations of their use of force as a way of threat, but not as an active use of force. Active use of force, of course, will be a intervention that we're gonna see better the thing of intervention with the R2P. But yeah, those are like the main sanctions of the Security Council. Remember, it authorizes and has the monopoly of the use of force. And with that whole thing of the general rule of the prohibition, there are certain rules in the terms of the use of force. First, every general rule has its exception. And the exception of the prohibition of use of force is in Article 51 of the UN Charter. I'm like 95% that that is going to be in your exam. If it is a case that includes many topics, use of force is definitely going to be there. So remember, Article 51 of the UN Charter. What does that article says? It basically says that it authorizes states to make well, that the states are entitled to the right of self-defense, individual or collective self-defense, when they are being attacked by another state. That individual, like if state A attacked state B, well, state B is entitled to attack state A. We're gonna see the necessity and proportionality of that attack, but that is individual self-defense. And collective self-defense is, for example, the NATO. It's an organization, that was created by a treaty, which is the most clear example of what is collective self-defense. I think it's Article 5 of the NATO treaty that says like if one state is being attacked, well, the other ones will answer to that attack as a way of collective self-defense authorized by international law. It doesn't say that in those words, but sort of it's something like that. So yeah, that's basically Article 51. One discussion that arises at the end somehow of the end of the 20th century, beginnings of the 21st century, was the so-called Bosch Doctrine with the preemptive and anticipatory self-defense. I hope that you remember that because maybe I think that that's a very possible question in your exam, the differentiation between those two. The Bosch Doctrine arises because no, yeah, it was the beginning of the 21st century. I remember now when they say like United States start to attack many states in the Middle East because mainly Iraq because they thought that they have a mass destruction arms. I don't know if that's the right name, but I think it is. And they say like we're not sure about if they have those arms, but we're gonna attack them to prevent the use of those arms. At the end, we all know nowadays that Iraq didn't have those mass destruction arms. There was no proof of Iraq having those arms. But anyways, the thing is that it arises the so-called Doctrine, and it is when a state is not sure that it's gonna be attacked, but I attacked first to avoid that second state to attack me first. I don't know if that's clear. It's like en español, ataco por si acaso, básicamente. Of course, that is not legal because that is the preemptive self-defense, if I'm not wrong. I will confirm you. But yeah, the legal use of force is the anticipatory. No, no, I'm mistaken. Marie, you remember this differentiation of anticipatory and preemptive? Is just that I always confuse them. Um,
Let me check my notes because I want to confirm if what I have in mind is correct before answering that.
okay, because if I don't remember wrong, it's like preemptive is Bush doctrine, anticipatory is like the legal one. But well, while Marie confirms, the other type of self-defense, what we think that is anticipatory self-defense, is that I have the whole like certainty that I'm gonna be attacked by another state. So I attacked first. That is legal. For example, as a fun fact, Putin, when he attacked Ukraine, he claimed anticipatory self-defense because they say like we have basically the troops of the NATO in the border between Ukraine and Russia. There is like no chance that we are not gonna be attacked, so we will attack first. And there is an example. It was quite funny. But okay. Um, in the scenario of self-defense, when a state make use of force because it was attacked first, there are two main rules. First, as the United Nations Security Council has that monopoly of the use of force, well, after I carry out such attack, I must inform the Security Council that, hey, I was attacked, so I made use of my right of self-defense. Inform the Security Council. And the second rule is that the attack of self-defense must be carried out under the principles of necessity and proportionality. So if I don't know, United States attacked Venezuela with missile, Venezuela cannot drop a nuclear bomb to the United States and vice versa. Some sort of it's more complicated than that, but it's the main rule of like the more general example to understand what is proportionality. You will see this very clear in Mary's explanation of IHL, a necessity that I must carry out such attack because it's the only way to protect my interest as a state. I don't know if I'm being clear, if
Okay, so
there's
I have the answer to the anticipatory and preemptive.
okay, so
So
preemptive is
preemptive is Bush doctrine. So it's not something posing a threat yet, but that may pose a threat in the future.
hmm,
And that's, well, illegal under Article 51. And then the anticipatory self-defense is not like in face of an imminent armed attack, just the armed attack is not has not happened yet, but it is very imminent. Like there's reason to believe that it's happening undoubtedly.
thank you. So there you have like the confirmation of the differentiation between those two doctrines. Remember, Bush doctrine, preemptive self-defense, and the legal one, anticipatory self-defense. There is like I have full reasons to believe and full certainty that me as a state is gonna be attacked. So I attacked first to avoid such attack. Okay, so another topic, part of the use of force are the peace operations. And it is in terms of the actions of the Security Council when a state in its internal affairs have certain complications in terms of peace and security, well, the Security Council can deploy a peace operation to reestablish peace and security as one of the main purposes, principles, and objectives of the United Nations and mainly of the Security Council. There are these type of, I think there are five, one, two, three, four. So there are five types of peace operations. I know that you didn't see this like really deep in class, so I'm not gonna explain this like really deep. I'm gonna explain another things about the peace operations. What you must know is that the Security Council can deploy the blue helmets that they are better known as the UN Army, something like that, but they're not like an army as a whole. They're more like military personnel that states give to the Security Council to carry out such operations. Um, those operations are going to be deployed depending on the stage of the conflict. If the conflict is like in its worst part and it's not like even close to achieve peace, well, the peace operation is going to be peacemaking. But if the conflict has already ended, the state is already in a transition process of reestablishing like the state as a structure, well, the mission is gonna be peace building. Don't mess with this. Some it's a little bit complicated, but it's not gonna be in your exam, so don't worry. Before I move on to the other things, is there any question? Everything is clear. I will assume everything is clear. Okay. So now I will share it with you the second part of the monitoring. You can see my screen again, right?
Yes.
Thank you. Okay, so in terms of, before I move on to the explanation of human rights, in terms of peace operations, we also have a really important topic that also I'm 99% sure that it's gonna be part of your exam because Juan Pablo personally loved this topic, so maybe he included. And it's the R2P, the responsibility to protect. Maybe you have heard of it. It's I wouldn't call it a principle, but more like a rule that was established in 2005 by the UN World Summit Congress. Something it was. the Summit Outcome Document of 2005. Right. Um, and in that conference, states analyzed like the previous situations in like in domestic systems that have been carried out that were that arise serious violations of human rights. For example, the genocide in Rwanda was one of the reasons why states created R2P, the situation in Somalia, and many others. So states became with this idea that was the responsibility to protect. The responsibility to protect is basically the actions that the states must carry out in order to prevent war crimes, crimes against humanity, genocide, and ethnic cleansing. Remember those four? Oh, they're here. I will pass I will pass this via WhatsApp for you to have it and to study the R2P because it's really important. And the main thing that you must know are the three pillars. First, that states has the responsibility to protect the population of their own states from the crimes that I mentioned: war crimes, crimes against humanity, ethnic cleansing, and genocide. The second one is that states must provide help to other states when there is a situation of the aforementioned crimes, crimes against humanity, and the others. And the third one is that if a state, say, no, not my own state, but another, fails to prevent the protection of such population, well, then there is like the authorization of intervention under the rules of international law in order to protect such population. In this third pillar, it arises like the whole debate with R2P because it can be seen as a threat of sovereignty, as that is like the main principle of international law, that the states are sovereign from one another, they are equally sovereign, and for that reason, intervention is prohibited, like the principle of non-intervention. But like then arise as an exception to the principle of non-intervention, the third pillar of the R2P. Um, States have attempt to claim R2P in order to carry out like some illegal actions, but I know R2P is really complicated because if an state wants to intervene in another state, well, it must claim like and really prove that it was with the purposes of avoiding genocide, war crimes, and those topics. That is like the main things you must know about R2P. And with that being said, we will pass to our last topic, that is the regime of human rights. As I was mentioning you, the terms of use of force and the whole topic of peace operations, all of that is like the stage where states are not allowed to make use of force. What happened when states make use of force? Mari will explain that. But in that whole process of prohibition and the use of force, the transversal regime that is present in all of those stages are human rights, because like the general notion is that human rights cannot be violated because they are like these general common notions of international law, because they are included in treaties that are ratified by most of the states around the world. In reality, we know that that's not entirely true, but anyways, we will see like the general things about human rights. I don't think that this must be really complicated because you must have like the main core notions. Um, Enrique always starts with this topic, making like a historical background of the first moments where there was like a discussion of human rights. You already know this. Carta Magna in England, like in the 10th century, something like that. But after many years, then when after the French Revolution, that they make the Declaration of the Rights of Men, basically they left other populations such as women outside such declaration. So after the Second World War, that is like the great like where international law arises at the most majority. It also arises not just with the UN, other treaties of human rights. And then we have the Bill of Human Rights, that are the main instruments of human rights that contain like the general framework of the protection of such rights. Those three instruments, also pretty sure that this may be a question in your exam. So memorize these three instruments are the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the ICCPR, and the is the, well, it's International Covenant, not Convention, International Covenant on Economic, Social, and Cultural Rights. Uh, you must make a clear differentiation. The last two are treaties, therefore they are binding. Remember, like the sources of international law are binding for the states that have ratified them. The Universal Declaration of Human Rights was a resolution of the General Assembly, so it is not a treaty, and therefore it is not binding. However, most of the provisions, well, not most, but many provisions of the Universal Declaration has become customary international law. It's really complicated to identify which specific articles are custom or not. That's another topic, but you must know in general that um, the Universal Declaration of Human Rights is a resolution of the General Assembly. In principle, it is not binding, but some provisions could be binding through its existence of customary international law. So yeah, that's like the main instruments in terms of human rights. And then we have two main systems that make the protection of human rights, the universal system and the regional system. In the regional system, you know that there are three, the European, the African, and the Inter-American. You in class, someone has a question? No? Okay. You include also the Inter-American system like really deep, and Mari is gonna explain that. I will explain like the general notions of the universal system of human rights that is divided into in the treaty-based organs and in the charter-based organs. In the treaty-based, as the name is really self-explanatory, are the organs that are created through a treaty. So, for example, here we have the CAT, the Committee Against Torture, because it's created by the Convention of the Prohibition of Torture. And the Human Rights Committee, it's created by the ICCPR, by the International Covenant on Civil and Political Rights, and like that with every committee that has the treaty that create such organ. So therefore, these treaty-based organs have many functions. One of them is hear the communications that an individual can bring to them with an alleged violation by the state of a provision of the treaties that created such bodies. Um, as the organs that are created by a treaty, those organs are the main interpret are the main interpretative body of the respective organs. So the Human Rights Committee is gonna be the main interpretative organ of the ICCPR. The Committee Against Torture will be the main interpretative body of the Convention for the Prohibition of Torture, and like that with every organ. And those are like the general notions you can know. Yeah, they make also um, conferences. I think that I don't know if all of them, but for example, the Committee again on enforced disappearing make conferences every year to review situations of enforced disappearing with the state parties of the treaty for the uh, prevention of enforced disappearing. And yeah, those are like the general functions of the treaty-based organs. Yeah. And the charter-based organs, just like to end this topic, are, like the name says, when they are created by a treaty also, but are specifically by the UN Charter. So therefore, their function is going to be more general and not such as specific as they are the treaty-based organs, because, I mean, the names are really, again, self-explanatory. The Committee on Elimination of Discriminations Against Women is going to know about such topics and only about the topics that are included in the convention. But the charter-based bodies are more general about like the most general framework of international human rights law. And the organ in question of the charter-based bodies is the Human Rights Council. Um, this is like this organ. I think there are 47 states part of this organ, and they make reviews of the situation of international law and human rights in general, like every 4 or 5 years. So yeah, they make like these summaries and informs of what is the situation of human rights, like in general, They accept recommendations and they submit recommendations, but again, nothing binding, as also the other communications are also not binding. But yeah, they make like a more general assessment of review, recommendations, and investigation of the alleged violations of human rights that can be present in states around the world. And I think that that will be like the most general things you must know about human rights. I don't know if, again, there is some questions or we can move on to the next topics. Okay. So, Mari, the floor is yours.
Okay, thank you. So that will be me. So let me know, please, if you see my screen. My screen?
Yes.
Yes. I think I'll turn my camera off because I don't have very good internet and my computer is also kind of giving up and I'm scared that maybe will bug. Oh, jeez. Okay, so I'll be talking to you specifically about the Inter-American Human Rights System, international humanitarian law, and international criminal law. So first, for the Inter-American Human Rights System, this is created in the framework of the Organization of American States, and we can consider like three foundational instruments. The OAS Charter, which creates the Inter-American Commission on Human Rights, the American Convention on Human Rights, also known as San Jose Pact, which creates the Inter-American Court of Human Rights, and this is very important, like the initials. If you see the little t, it's the court, and if you don't see a t, then it's the commission, and it works the same in Spanish. And then we also have the American Declaration of the Rights and Duties of Men, which, as a fun fact, as you heard in class, preceded the Universal Declaration of Human Rights. And this, as Silvia was telling you on the Universal Declaration of Human Rights, this one is also
Maria Alejandra,
not
sorry for
binding.
interrupting you.
Yeah.
Sorry, I cannot see the title. I don't know why there's like a box. I cannot see
Oh,
the
I
title.
think that's the meeting like thingy. Um, is that better? Or maybe if I don't present it and show it like this.
Oh,
Is
yes,
it
right
better
there.
this way?
Right there.
Is it better like
Yes,
this?
thank you.
Yes, okay. So, as I was telling you, so for the American Declaration of the Rights and Duties of Men, this is not binding. It's a soft law instrument, but an important thing is that it may be binding for the member states that have not ratified the American Convention on Human Rights, and the Inter-American Commission on Human Rights might like analyze violations to this declaration for states that are not members that are members of the OAS, sorry, but that have not ratified the convention. And for instance, like an example, it's United States is not part of the San Jose Pact, but it is part of the American Declaration of the Rights and Duties of Men, and it is also part of the Organization of American States. So as for numbers, for the General Assembly of the OAS, we have 35 members, and there they vote, they have equal voice and vote. It's a political body, it makes decisions. And then for the states parties to the Inter-American Convention, we have 21 states. And lastly, for states that accept the Inter-American Court's jurisdiction, there are 19 states. So very little number of states in comparison to what members are in the OAS. So now for the Inter-American Commission on Human Rights, it is a quasi-judicial and political body, and it has like different I don't want to say obligations, but like maybe functions. So first, the promotion, it promotes and protects human rights across the Americas. It's also protects, it receives and analyzes and investigates individual petitions, and we'll delve upon this item later. It's also quasi-judicial as it issues a report on the merits. It is not binding, but it is required to go to the court. So the Inter-American Commission on Human Rights is the entry point for the victim of a human rights violation to access eventually the court. And another important thing is that it also issues recommendations. So it may, I don't know, for instance, for a violation that Colombia might be doing on, I don't know, like deploying a X and Y operation that might affect human rights, and someone says like, hey, this is affecting my right, and goes to the Inter-American Commission, the Inter-American Commission might recommend for Colombia to stop said operation, but it is not binding. Although a fun fact is that Colombia takes these recommendations as binding. It also may establish precautionary measures, so before the recommendations are issued, after the Commission finds the state responsible, and the precautionary measures are before to prevent irreparable harm in grave and urgent cases, but again, these are also non-binding. It's also the one in charge to submit cases to the Inter-American Court of Human Rights when a state fails to comply with the recommendations set forth in like in the merits finding, but it also may just not because of the not compliance, but may just take the case up to the court. Another function is that it may also request advisory opinions from the Inter-American Court of Human Rights, as can do states. Now, an important thing is which are the treaties that belong to the Inter-American Corpus Juris that will be the ones for which the Inter-American Commission and the Inter-American Court has like competence and jurisdiction. So, first of all, is the San Jose Pact, the American Convention of Human Rights, and they will have full competence over all of this treaty. For the San Salvador Protocol, which discusses economic, social, and cultural rights, it only has like for trade union rights, so sindicatos in Spanish, and education rights. For the Convention to Prevent and Punish for Disappearance, it's like full. For the Inter-American Convention to Prevent and Punish Torture, it's also full. For the Belém do Pará Convention, discusses violence against women, it only has for the Article 7 in conjunction with Article 12. And finally, there is an Inter-American Convention on the Protection of the Human Rights of Older Persons, and that's also like they have full competence over this treaty. So now, as to who may file a claim before the American system, so natural persons individually or as a group, and it may act through a legal representative. But legal persons are not, subject of human rights before the Inter-American system, except when they are indigenous and tribal groups, when there are trade unions like the San Salvador Protocol, because of the rights is established for them, and also there must be determinable groups of natural persons. For instance, you might call the Unión Patriótica case versus Colombia. So you might think that, okay, so this political party had legal personality. Well, yes, but before the Inter-American system, it was not like a political party, but a determinable group of people. So, and for the who might, establish what determinable means, that's a burden for the state. For instance, it can use the Unidad para las Víctimas to like create a list of who might be these group persons that are being affected. And then as for against whom a petition might be filed, it has to be a state that has ratified the Corpus Juris treaties, or at least the treaties from which the violation stems. So for example, I don't know, it might not have even ratification to the Belém do Pará Convention, but the violation is from a right that it's in the San Jose Pact, then it can go through. As so long as this convention, the Belém do Pará, which has not been ratified, is not like claimed of the violation. And the state must have also accepted the court's jurisdiction. So if the state has not accepted the jurisdiction, then the case can only be heard by the Inter-American Commission of Human Rights. And just as a fun fact, I have a little comparison note here that in the European system, legal persons may appear before the court or the tribunal for certain rights, the European court. For example, the right to property, and in the African system is also like for ethnic and tribal communities too. So maybe not, for example, like a fun fact to know. Now, as to the procedure before the commission, we have the initial petition. So I don't know, let's create a case, for example. So let's imagine that the right to education of Pepita has been violated. And well, the right of education is here in the San Salvador Protocol. And let's say that it was Colombia, and let's say that Colombia has ratified this protocol and has, well, done everything right or everything wrong for this violation. So there goes the initial petition, then the commission makes a preliminary assessment. So if it was filed within the reasonable time and like formal requirements, it's like a web page that you can like fill out information. So like name, place, address, um, email address, and information like that. So it will check this, and then it will transmit this petition to the state for it to, say its arguments on if this right has not been violated. And then there goes to the admissibility state. So this part questions if the petition might be admissible before commission or before the Inter-American system. So for instance, if there has not been a proper exhaustion of lawful remedies, that's like a thing for it to be unadmitted. So that would be like that stops at this stage. Then for the merit stage, it will analyze precisely what violations were by the state and like analyze this upon the specific situation or the specific petition of the victim. And then it will issue a merits report in which it states if the state was or not responsible, and it issues or it may issue recommendations. So then what happens? Like it follows the compliance of the state. The state complies, then it archives the case. If it requires an extension to like comply, then the commission keeps doing follow-ups. And if it doesn't comply, then it may go to the Inter-American Court. But as I said before, if it may just go through to the court, like the American Commission might decide to just pass it on without it not complying. Then another important fact is that a friendly settlement, it can occur at any time before it arrives to the court, so before this part of the merits report. And there will be like a signature of a memorandum of understanding, and then the commission will like supervise that this memorandum fulfills and complies with the rights and everything that's established in the Corpus Juris, the Inter-American Corpus Juris. And for other special tools, we have the provisional measures and the precautionary measures. So as I said before, provisional measures are taken by, the precautionary measures are taken by the Inter-American Commission of Human Rights, and they are non-binding. But the provisional measures, they are binding, and they are taken by the Inter-American Court. So this may be requested even if the case is just in the commission. So like for protecting a right of that might be urgently violated or that it's like in extreme gravity and extreme risk. Now for the Inter-American Court of Human Rights, it has like three main functions. The contentious, which is solving cases alleging violations of the convention by a state party that has accepted its jurisdiction. The supervision of compliance, it supervises compliance with its judgments, and it submit like periodic progress reports, and the court may clarify the scope of its orders. For the advisory, it issues opinion on interpretation of the convention or other human rights treaties from the Inter-American Corpus Juris. So for instance, Colombia and I think it was Chile, if I'm not mistaken, that requested an advisory opinion on the obligations of states for environmental for the environmental obligations. So this is another function of the court. And then it is really important before the court that there is no ordinary appeals against the judgment, and it may exceptionally state or the victim request for an interpretation of revision based on new facts, but this is really rare, like it doesn't happen that much. Now, for the like, I think it's one of the most important parts of the Inter-American system as a whole, is that one of its main pillars it's integral reparation, and it goes by the principle of restitutio in integrum. So it's one of the most complete forms of reparations for human rights violations everywhere. Like, for instance, the European system doesn't have this, the African system doesn't either, but we have it here. And it's just sort of like different forms of reparation. So the normal ones that you may know: restitution, indemnification, rehabilitation, satisfaction guarantees, non-repetition guarantees, and one that's created by the system, which is the Life Project, which like basically says that violation of human rights may alter the life project of somebody. So for example, a rape may, like, result in a child that will alter the life project of the victim. So things like that. Or for example, I don't know, a murder of a close relative that also may alter your life project, and things like that. So this is it for the Inter-American system of human rights. I don't know if you have any questions, if everything's clear. So I'll take it that as everything's clear. So now for international humanitarian law, I like to think, as Silvia was mentioning, that each regime is like a result of the other. So for instance, the regime that results from the continued use of force would be the IHL regime. So an important distinction, really important distinction, is when it applies. So international human rights law, sorry, as Silvia was mentioning, it applies at all times. So yes, even during our conflicts, there is international human rights law. International humanitarian law, on the other hand, it only applies during armed conflicts. And then international criminal law, which we'll see later, it sanctions violations of the previous two regimes. So international human rights and international humanitarian law, but we'll just like deal with that later. So as the International Criminal Tribunal for the former Yugoslavia, in its case on the prosecutor versus Furundisa, I think it's pronounced like that, I don't know. The essence of the whole corpus juris of IHL and international human rights law rests in the protection of human dignity. So that's like a very important pillar, human dignity. That is their reason to be. Now, an important distinction that was also made, I think, by the International Court of Justice in, if I'm not mistaken, the advisory opinion on the Palestinian wall from 2004. It says that international human rights law applies during armed conflict too. It applies like in peace and in armed conflict, but the difference is that international humanitarian law, it's lex specialis. So it is a different threshold. So for instance, as you may know, in international human rights law, murdering someone is completely legal, but then in international humanitarian law, it is not. It depends on who that person is and how was the operation, where was it, and just things that we'll discuss later. But it does not mean that human rights law does not apply. It just means that international humanitarian law is lex specialis. Now, for the sources of IHL, it was like born from customary practices, and then it was conventionalized. So we have treaties, which is, as you know, the first main source. We have the Geneva Conventions, we have the additional protocols, we also have like the Convention on the prohibition of indiscriminate weapons and on like chemical weapons and everything else. We also have international custom, and if you like want to investigate on that, there's a really good document from the International Committee of the Red Cross, like that compilates all of the international custom for different type of conflict. And then there's also jurisprudence that might be from the International Criminal Tribunal for the former Yugoslavia, the International Criminal Tribunal for Rwanda, Sierra Leone, which other, like the also the International Criminal Court and, well, everything else. An important thing for international humanitarian law, because it will determine which obligations are applied, is the classification of armed conflicts. So first we have like the international armed conflict, and we can find that in Common Article 2 to the Geneva Conventions, and it is in situations of a declared war between two or more states, even if one of them does not recognize the state of war. So, I don't know, for instance, Colombia and Venezuela, let's speak to random countries, they start like fighting each other, but then Venezuela doesn't recognize a state of war. If it's a declared war between them two, then it is an international armed conflict, even if Venezuela is just like not recognizing the state of war. So this international armed conflict, it has more instruments than the non-international armed conflict. It has like the four Geneva Conventions, and it has also additional protocols. But for non-international armed conflict, we have only Common Article 3 to the Geneva Conventions and additional Protocol 2. So that's why it's important, the distinction, to know like which treaty applies. And yeah, so that one. There's also certain circumstances in which it might be considered an international armed conflict that are found in additional Protocol 1. I think it's Article 2 or 3, just like at the beginning. Now, for non-international armed conflicts, it's a conflict between the state and organized armed groups, or between those organized groups. So I'll discuss later like what specifically is an organized armed group, but that's just the definition for now. And then we also have an internationalized armed conflict, as we saw in the Yugoslavia case, and that was developed by the International Criminal Tribunal for Yugoslavia. So it is where a state supports an organized armed group opposing government forces, and it develops the theory of overall control to these armed forces. Now it's, I don't know if you have heard of like the global war on terror and those crazy things that the United States says. Well, that's not a proper classification of armed conflict, and it is not recognized as such. Another important thing is that in the Tadic case, which is from the ICTY, the tribunal said that many international armed conflict law will also apply to non-international armed conflicts law. And the, well, organized armed groups, they do not have the same rights as a high contracting party to the Geneva Conventions. So, for instance, as we'll see later, I think, organized groups, like their people are not qualified as combatants and thus are not awarded a prisoner of war status. Now, for the distinction between combatants and civilians, this is really important for the principle of distinction. So, like, delve upon the different principles, fundamental principles of international humanitarian law. So this is a an intransgressible principle. It's the cornerstone of IHL, because IHL, its main reason of existence is to protect civilians. That's basically it. So it's really important, this principle. So it says that when fighting, the combatants must be distinguished from the civilians. So combatants is members of the armed force of a party, which only applies in international armed conflicts. As I said before, for organized armed groups, there is no combatant status and thus no prisoner of war status. And there's a presumption that when in doubt, the person is a civilian. Like if, I don't know, I fighter for the army and I see someone and I'm not sure which is like its classification, then I must assume they are a civilian. It's really important, civilian population shall not be attacked, shall not be under any circumstance under attack, but they lose this protection when they're direct participation, when they're performing a direct participation in hostility, sorry, and just for the duration of that. So, for example, Pepito is directly participating in hostilities and he stops and he goes, I don't know, home or whatever. At that time, he may not be subject of attack because he is not directly participating in hostilities at the moment of the attack. How do you know if someone is directly participating in hostilities? Then there must be a damage threshold. There must be direct causation between the action that they made and the damage caused. And there must be a belligerent nexus, so like sort of this political ideation or belief behind what they're doing and whatever it is a reason that the like armed conflict is developing. So for example, if I'm in a situation of conflict and I find a rifle and I start shooting to protect myself, then I'm not directly participating in hostilities because although there is a damage threshold and direct causation, I have no belligerent nexus. I'm just like fighting for my life and defending myself and not like believing that I'm supporting whatever it is the reason that they are fighting for in the armed conflict. Now, there is also this distinction of military objectives and civilian objects. So, civilian objects is like defined in the negative. So, whatever it is not a military objective will be a civilian object and shall not be attacked. And military objectives are those that by nature, location, purpose, or use contributes effectively to military action and destruction. And it also offers, its destruction well offers a military advantage to that party. So this is really, really important. As you may see, this will really depend on how you argument it. Like it can go either way. Now, for the other principles of international humanitarian law, we have military necessity, which says that violence and destruction in war is permitted but within limits. So the measure taken must be indispensable to a military objective. This measure must be necessary for the military operation, and necessity will cease as soon as possible. So as soon as something may be deemed not necessary, it will be not necessary. It also cannot be used if prohibited elsewhere in international law, for example, the prohibition of indiscriminate weapons. So it may be necessary, it may be indispensable to a military objective, but if you will perform it with an indiscriminate weapon, then it will not be possible. So, for instance, well, here's the example indiscriminate attacks, also failure to take precaution, which we'll see later, and directed at civilians. So, for instance, if there is a hospital, which that's really important in IHL, and there are like sick people there and everything, I cannot, for any reason, take that down because that it is, well, I'm directing the attack at civilians if the hospital is full of civilians. And also, well, there is also a special Geneva Convention on the wounded, and that's just another topic. So for the precaution in attack, the commander must obtain all necessary information to perform the attack. Just it should not like just point to a map and say, "Hey, let's attack here." It must gather the necessary information. It must choose the weapons that will cause the least damage. So for instance, maybe deploying the bomb through a drone will cause more damage than by hand. I don't know. I don't know about this, but maybe. So then you should choose the one that causes the least amount of damage possible. It will also cancel attacks if there will be excessive casualties expected. So this is really important because, casualties is a thing that happens in conflict and it is not forbidden for casualties to happen, but excessive casualties and casualties that are a result of a lack of precaution and proportionality, then that will be illegal. And it must also give effective advance warning when possible. So if there will deploy an attack on a region and there are civilians there, if possible, they should warn those civilians that an attack will take place for them to take cover or to like flee the zone. I don't know. And for proportionality, so even when a military objective when an object is indeed a military objective, it cannot be attacked if it is expected civilian harm that is excessive in relation to the military advantage. So it may fulfill all the other like requirements. So it might comply with the principle of distinction and it is a military objective. It might follow with military necessity and it is necessary. You might take all the precautions in the attack, but if you sense or if you have information that it will cause excessive civilian harm in relation to the military advantage, then it is illegal. So proportionality would always end up being a judgment call, and for that, there are different levels or analysis levels. So there's first the strategic level, which sees the whole campaign lens, so harm must compensate the overall campaign. And as you might imagine, this one is really low. So in this one, the civilian harm will like be easier for it to be justified. Then we have like sort of a middle point, which is the operational level, and it analyzes harm against a specific military operation. So like a campaign, which is a strategic level one, includes several operations. So this will analyze that civilian harm for the different operations or for a specific one. And then for the tactical level, which is like a very high threshold to meet, and for in this part, the civilian harm will be really hard to justify, will be to analyze each individual act of violence within an operation. So what are some sort of situation that present themselves like with this proportionality principle? That would be, for example, I have a building and I don't know, let's imagine that I am, let's take two countries in war, like Ukraine and Russia. So let's say that I am a commander of the Ukraine forces, right? And then I know that in a building where there are civilians, there is, I don't know, Vladimir Putin. So am I allowed to bomb that building because he is there, and that will offer me a great military advantage and everything else? And then, but there are 20 civilians there. Does that justify to like bomb there and, well, cause excessive damage or excessive harm to those civilians? So, well, those are the sort of type of discussion that arise from these principles. And also an important aspect here is that the analysis should be taken for the reasonable commander. So what would a reasonable commander would have done? So like for instance, um, if the a reasonable commander would have had the information that you had, would have he attacked or not? So that is sort of the threshold. And that will be it for the like the part on international humanitarian law. And I know that it may be tricky, especially these principles. So I want to know if you understood them correctly. Okay. So then I will say a little case to see if you like sort of grasp this correctly. So, for example, let's take the Ukraine and Russia example again. If I'm a Ukrainian commander and I received information from some newspaper, I don't know, that an old factory and there are civilians nearby, and an old factory was like taken as a base for operations from Russian troops. And that those Russian troops, it would offer me a military advantage to like kill them because they are the ones that are causing harm in, I don't know, the Lugansk region. And I have that information and I chose the weapon. Can I attack, or what am I missing to analyze? So someone that wants to answer the little case. No one?
If you participate, we might consider and talk with Enrique and Juan Pablo to give you bonus.
There's actually no right or wrong answer properly. Like the thing of IHL, which is kind of fun, is that everything is debatable and you can argument everything. Okay. So what I would answer to that question would be that you should obtain all necessary information, and finding something on the newspaper is not all necessary information to deploy an attack. And also that if there are civilians nearby, you should analyze the action would cause excessive civilian harm as to like comply with the principle of proportionality. But you may also try to use the argument of the strategic level and that that specific operation would, compensate the possible civilian harm to the overall campaign and just things like that. So now for our last topic on international criminal law. So international criminal law, its main purpose is to like counterattack or to protect the world from what it's described in the Rome Statute in its preamble as the gravest violations to human rights and to international humanitarian law. So the gravest crimes to humanity. So that's just of the definition, like the gravest, more atrocious, heinous crimes. Those are the ones international criminal law protects or, well, criminalizes. So we have like ad hoc tribunals and then we have the International Criminal Court. So for ad hoc tribunals, we have the Nuremberg, or we had because they're not active anymore, Nuremberg, Tokyo, ICTY, and ICTR. There's actually a sort of residual mechanism, which is a combination, but that's, if you want to research it, it's interesting. So these tribunals, especially the ICTY and the ICTR, they really helped to like form international criminal law and just all of its like principles and everything because of its development. The Nuremberg tribunals, more or less because they are really criticized for not functioning properly. So that's what I say that principally the ICTY and ICTR. So now the main treaty is the Rome Statute, which is it establishes like the crimes for which the court has jurisdiction. So a really important thing is that the court has complementary jurisdiction. So the ICC will only know of cases when the state is unwilling or unable to genuinely prosecute. So for instance, in Colombia, like the International Criminal Court is closely working and following up with the Jurisdicción Especial para la Paz because of like the whole, armed conflict situation here. But in cases such as, for example, Uganda, because there is a situation in Uganda, it is investigating this country because the state is unwilling or unable to genuinely prosecute the people responsible. Or, for instance, maybe a more mediatic case would be that one of Palestine or of Venezuela, which are also under investigation from the ICC. So how can a case fall onto the lap of the ICC? It would be by a referral by a state party or a referral by the UN Security Council, or it may also be proprio motu initiated by the ICC prosecutor. So for instance, for the case of oh, I forgot. But I think it was Ukraine, yes, that there was a list of like 34 states that signed requiring or requesting the court to initiate an investigation. So just that's a way by a state party. For the UN Security Council, I think in the case of Liberia, or Libya, the situation in Libya, it was referred to by the Security Council. And for initiated by proprio motu, I'm not sure of an example. And now for the crimes for which the ICC has jurisdiction. So, as I said, the most serious crimes that concern international humanity as a whole, and all this like paraphernalia of how to name the crimes are really, really bad. So, first of all, we have genocide. So, acts committed with intent to destroy in whole or in part a national, ethnical, racial, or religious group. Then crimes against humanity, which are acts committed as a part of a widespread or systematic attack directed against any civilian population with knowledge of the attack. For war crimes, we have grave breaches of the Geneva Convention and other violation of laws and customs applicable to armed conflicts, so what it's called the law of armed conflicts. And lastly, the crime of aggression, which is planning, preparation, initiation, or execution of an act of aggression constituting a manifest violation of the UN Charter. So if you might like connect this with what Silvia was saying, so an unlawful use of force. What it is important here is that genocide has a dolus especialis, which we'll see later, yes. And an important distinction is that crimes against humanity are not war crimes and are not to be confused. So crimes against humanity are grave violations and systematic ones to the international human rights law regime. And war crimes are grave and heinous violations to the international humanitarian law regime. So that is really, really important. Another important thing is that the ICC, or International Criminal Law as a whole, it prosecutes individual, like the highest commandeers, the responsible ones, those who gave the orders. It does not uh, solve cases of states. So, for instance, Colombia may not be sued before the ICC, but a special commandeer from Colombia's forces or from a organized armed group, then he or she might be tried by the International Criminal Court. Another important aspect is that for the crime of aggression, like genocide, crimes against humanity, war crimes, they their application started with the Rome Statute, but for the crime of aggression, it was later, I think in 2018, with the Kampala agreements. So not all states are part of the Kampala agreements, which is also important to note. Now, for genocide, it protects groups, national, ethnical, racial, and religious. And there is a dolus specialis, which means that there must be intent to eliminate these groups, not just not just the action, but the dolus specialis, which is really a high threshold to prove. So, for instance, in the case of the South Africa versus Israel, that's like a key point to like prove this dolus specialis of genocide. Well, but that the case is before the International Court of Justice. What are the types of genocide? Killing members of the group, causing serious bodily or mental harm, deliberately inflicting conditions of life or physical destruction, imposing measures to prevent birth, which is forced reproductive control, and forcibly transferring children to another group. And well, these are in the Article 6 of the Rome Statute. Then for crimes against humanity, it's a widespread or systematic attack on civilian population, as I said before. So it must be like an organizational policy or like things like that. And some examples will be the ones here. So murder, extermination, enslavement, deportation, or forcible transfer, imprisonment, etc. Then four, war crimes, those are the great breaches to the law of armed conflict. So there are like just four Geneva Conventions and like I think three additional protocols. So there are plenty of examples and plenty of like ways to commit war crimes. But some examples might be willful killing, torture or inhumane treatment, direct attack against civilian population or against civilian objects, attack against humanitarian and peacekeeping personnel, and things like that. And then for the crime of aggression, it would be what I said before, and the execution of an act of unlawful use of force, which would mean a violation to the UN Charter. And that person must be in effective control of state political military action. So, for instance, an invasion or attack by armed forces, bombardment, blockade, etc. And as I said before, it was like in the Kampala agreements, in the Kampala conference, or following Kampala agreements, that the jurisdiction was activated. Okay, but it is also important that there must be like for jurisdiction, there must be material, personal, temporal jurisdiction. So material will be the crimes, then personal will be who the person is. Then temporal jurisdiction will be like when did the state ratify the Rome Statute. And then for like, I forgot the name, but it's the one in the place. It's called Razione Loci. I don't remember how it is said, but then that would mean that it must be in the territory of a state that has ratified the statute, and also could be like committed by a person from the state. So that will be also a way for the court to have jurisdiction. But for instance, as it is in the case of Palestine. So Palestine ratified the Rome Statute, I think it was in 2015. And for instance, Benjamin Netanyahu is being tried, although Israel is not part of the Rome Statute because he is committing or allegedly committing those crimes within a country that is part to the Rome Statute. Now, what are the objectives of international criminal law? Retribution, so to punish violations and recognize the victim's pain and, well, the wrongdoing that's been done to them. General deterrence, so it will prevent the commission of crimes by others, so really similar to like national criminal law. Then specific deterrence, it would prevent the specific perpetrator from reoffending. And rehabilitation is like the last one, which is reaffirm faith in the international legal norm. And these are like sort of debated. So for instance, a trial chamber from the ICC will say one thing, and then the appeals will say another one, like another objective, and then the ICTY also has other ones. So those are just like some sort of the main ones. So as I said, sources, treaties, such as the Rome Statute, and just following agreements such as the Kampala ones. General principles such from like criminal law, like nullum crimen sine lege, nulle pena sine lege. The customary law, so not a formal source as such, because the legality principle of international criminal law, but it is influential. And then also jurisprudence of other tribunals, so maybe the ICC or ICTY, ICTR. And what are the challenges and limitation of the ICC like right now? So there are political issues, so Security Council may not refer cases if they are political. So for instance, if United States is committing a grave human rights violation and systematic one, and then they are part of the Security Council, like they have veto power, then they would never send their own case to the ICC. And furthermore, they are not even part of the Rome Statute. Then there's also an economic issue because they have limited funding. There is a lack of state cooperation. So the International Criminal Court, they don't have a police system. So for instance, if there is an order of arrest against Benjamin Netanyahu, then there must be cooperation of states to bring him like surrender him before the court. There's also the limited jurisdiction for the crime of aggression because of the Kampala Agreement. And lastly, war crimes are committed as a part of a planned policy large-scale commission, which will in some occasion make it difficult for it to be like judged before the court. And well, that would be it for international criminal law. I don't know if it's clear. I'm not sure if you saw like the difference between the principle of legality, like from national criminal law and for international criminal law, and if you like want to review that. Okay. So I'll take it as if everything was clear.
I think everything was clear.
Okay. Thank you, Carolina.
Okay, so I will stop recording now. Wait.